CDA District Court of the County of Wichita, State of Michigan, now having session, the
You may be seated. Judge called the case of the people versus Rayshawn Dawson. 2 cases.
government.
Carolyn Foster Tucker on behalf of Rayshawn Dawson for one of the cases.
How come you can't find people? Where's your client?
Your Honor, I believe he might be on the Zoom.
I think he might be Motorola.
I don't know what he's doing. Motorola. Is he waving?
Hello,
Hello, what's your name?
how you doing? Rayshawn Dawson.
Thank you. All right, what are we doing? Nice of you to arrive.
On behalf of Mr. Dawson. We are going to be requesting an adjournment. Mr. Dawson's, we could not reach him this week. We also just got extra video on his case, so we'll need to review that on my case, Your Honor.
And we're just requesting an adjournment to track the cases together.
Public cause conference, October 30th, 2025, 9 a.m. Bond continued on both matters.
Your Honor, can I address Mr. Dawson real quick about his contact information?
His contact information? You need him to contact you guys?
Yeah, just
Mr. Dawson,
Yes,
I need you
sir.
to call the public defender's office. Their
Okay,
number is
have my phone.
6970.
say it
You
one
need
more
to
time,
give-
Judge. Say it one more time, Judge. Okay. Okay. I got it, sir.
Call there, make sure that they have a good phone number and email address for yourself.
Yes, sir, I got you.
Thank you. You need to do that right when you hang up,
I will.
and I'll be checking.
Who's the lawyer? Who do I ask for?
Mr. Dawson, we've talked so many
You
times.
don't have to, you do not have to ask for anybody. Just make sure they got your correct information.
Yes, sir, I got you.
Thank you.
Thank you.
Thank you, Your Honor.
I just had to be here all day. Court calls the case, people versus, is it Joya Wallace Taylor? Joya?
Carolyn Foster Tucker on
That's too
behalf.
many letters.
Fine.
Fine, I'll do it when she gets up there. Go ahead.
Joya Wallace Taylor.
State your name.
Joya Wallace Taylor. Joya Wallace Taylor.
No, I heard you.
Oh,
I'm just in my head. Why do you have the 3 letters at the end? That's a lot,
I know.
right?
That's
You talk to anybody about that? Okay.
I need to.
All right.
I had to learn how to spell that.
It's corrected me. I don't know what that's. All right, what are we doing?
Your Honor, you should have a plea form.
A plea form? Yes, I do.
That's correct, Your Honor. The people are adding an account to it, district fees, 750-170, and misdemeanor or $500 fine. Upon a successful plea to that, count 1, possession of the taser, the felony would be dismissed as long as the defendant does agree to forfeit the taser. Did you believe it's already in police custody?
That is correct, Your Honor.
Is that sworn?
Right here. You solemnly swear to affirm that what you're about to give will be the truth, whole truth, and nothing but the truth, self you got. Thank you, man.
Joya Wallace Taylor.
Ma'am, it's this court's understanding that you're going to plead guilty to the charge of disturbing the peace. That's a misdemeanor punishable by up to 90 days of jail, $500 fine plus court costs. You understand that?
Yes.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. And all of that? Still wish to plead guilty? And to that charge, how do you plead?
You have to speak.
Oh, guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes,
You understand you're giving up your right to appeal of right.
yes,
Are you on probation or parole?
no,
Has anybody promised you anything other than what's been stated here today?
no,
Anybody threaten you or coerce you?
no,
You're doing this voluntarily
yes,
of your own free will
yes,
and because you believe that you're guilty?
yes,
On the date of June 22nd, 2024, at the location of 2954 Washington Avenue, Pittsfield, or Ypsilanti Township, Washington County, State of Michigan. What did you do that makes you think you're guilty of disturbing the peace?
I had a taser.
Okay. Were you around a group of people?
Yes,
Did something happen?
yes,
Did you pull the taser out?
no,
Did you show the taser?
no,
Okay. Somebody might want to wonder.
Were you involved in an altercation with another person?
yes,
And did the police respond out?
yes.
Did they find that the taser was in your possession?
I didn't pull it out, but yeah.
The fight itself, well, I can take the higher.
We're not charged, the fight didn't get charged, Your Honor, but, they
Okay.
did find it in your possession as a result of being contacted for that.
All right, I'll take the factual basis to the higher charge.
Thank you, Your Honor.
All right. Ma'am, I would have to advise you that if between now, the time of the acceptance of the plea and the time of your sentencing, if you commit misconduct as defined under the Michigan court rules, that any sentence evaluation or recommendation the court would no longer be bound by, and you would not be entitled to withdraw your plea. You understand that?
Yes,
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
Mm-hmm.
And have I complied with the court?
You are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
November 13th at 10 a.m.
November 13th, 2025, 10 a.m. before Judge Washington.
Thank you, Your Honor.
Thank you.
mhm,
Joya, your bond is continued. Go on. I don't, I think it was with that other one, but court does call the case, People versus Stacy Lincoln.
Trevor Maybell for.
David I. Goldstein appearing on behalf of the defendant. Your Honor, we have not yet received the discovery. I did discuss that with Mr. Maybell this morning. He indicated it would be forwarded to me, so we're asking for a brief adjournment.
Your name, sir?
Stacy Lincoln.
Thank you. Probable cause conference, October 30th.
Let me check, Your Honor. That'll work.
2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case of the People versus Jaron Jacobs.
Good afternoon, Your Honor. Sam Bernstein with and on behalf of Mr. Jacobs. Mr. Jacobs, could you please state your name for the court?
Jaron Jacobs.
We're asking for a short adjournment, Your Honor. We're going to resolve this case and just need a little time.
Probable cause conference, October 30th, 2025, 9 a.m. Bond continued.
Could I ask one thing about bond, Your Honor, please?
Go ahead.
Mr. Jacobs is wearing a scram tether right now. We're asking for the court's consideration to transfer him to SoberLink testing. He works for Lush Lawn. It's a landscaping company. He wears heavy boots for the work that he does. It's not like impossible to wear both at the same time. It's just very difficult. So hoping he can test several times a day with a SoberLink in its place.
In response from the people,
Maybe to your discretion. Your Honor.
why was he put on a scram in the first place?
I don't have any.
Violations, so my notes, there is. Count 2 is alleged possession of a weapon.
Do you have a BAC when he had that position? Because now I can understand why he's placed on a scram.
No, there is not.
Motion for change in bond is denied at this time. Thank you. Court calls case of the People versus Kelvin Patterson.
That's close, people.
Thank you, Your Honor. Your Honor, Christopher Bogar on behalf of Alvin Patterson. Mr. Patterson, please say your name for the record.
Calvin Patterson.
And Your Honor, we did have the opportunity to speak to the prosecution regarding this matter. We are asking for an adjournment. There is still some outstanding
Fill out
discovery.
a green sheet.
No, Your Honor.
Probably should have told you to do that.
I forgot, Your Honor, I apologize.
No, it wasn't your fault. It's all these people. They should have helped him out. How much time are you looking for?
Your Honor, are they held on Thursdays? November 6th, Your Honor, if possible.
A month? On a weapons case? What do we do? What? I don't know.
I will let the court know as well, the defendant at the time was arrested on September 26th, which is a couple weeks ago. There's an OWI connect, because this is, we don't have the lab back yet, so I do expect we're gonna have OWI of those.
Come
Show
back.
what I think that they're gonna show based on what I can read.
All right, I'll give it November 6th, 2025, 9 a.m. bound continued.
Thank you, Your Honor.
I'll sign the green sheet when it gets. Court calls case of the people versus Earl Haynes.
Assistant Public Defender Davi Lebo on behalf of Mr. Haynes, who stands to my right. Mr. Haynes, could you state your name, sir?
Earl Haynes? Just make sure they're out. All right.
And you're requesting an adjournment. We're still engaging in some plea discussions.
Conference October 30th, 2025, 9 a.m. Bound continued.
Thank you, Your Honor.
Court calls case of the people versus Carlos Hicks.
Assistant Public Defender Jay Bellinger on behalf of Mr. Hicks, who approaches. Mr. Hicks, can you please state your name for the record?
Hicks. Thank you.
And Your Honor, I am just asking for a 2 to 3 week adjournment. I have asked prosecution to look into an aspect of one of his cases, and I'm trying to negotiate on the other.
October 23rd, 2025, 9 a.m. Bound continued. Both cases.
Thank you, Your Honor. I'll be in touch.
Court does call the case of people versus Randy Hockenberry.
And then on behalf of the people,
Assistant Public Defender Sandra Wright on behalf of Randy Hockenberry. Can you state the record?
Thank you, sir.
Your Honor, I'm asking for an adjournment. There's some investigating I want to do and to speak with the prosecutor.
Without objection, probable cause conference October 30th, 2025, 9 a.m. Bound continued.
Thank you, Your Honor.
Court calls case of the people versus Dexter Hubbard. Barry. Yeah, you two shouldn't be together. I'm just saying, I think you guys know why, but I'm just saying. Go ahead. Yeah, just as that wasn't a good thing happened.
Sorry, Judge. Good afternoon, Assistant Public Defender Lauren Pearney on behalf of Mr. Hubbard. Mr. Hubbard, state your name for the record, please.
Dexter Hubbard.
We're asking for an exam date, Your Honor.
All discoveries complete.
Yes.
People have their witnesses available the 21st. Preliminary examination will be set October 21st, 2025, 9 a.m. That's before me. Bond will continue. Thank you. That's an in-person hearing, sir. Court does call the case of people. Andra Hunter.
Assistant Public Defender Davi Lebo for Mr. Hunter, who's approaching to my right.
Your name, sir?
Yes, Andrew Hunter.
Thank you.
And Your Honor, we did just receive the media in this matter. There are about 26 videos we need to review, so we'll be asking for an adjournment for that purpose.
October 23rd, 2025, 9 a.m. Bound continue.
Thank you, Your Honor.
Those case people versus Amanda James.
Trevor Mayville for the.
Assistant Public Defender Davi Lupo for Ms. James. Ms. James, are you present, ma'am? Your Honor, may I go check the hallway for her?
No. Did you look before?
Yes,
Have you seen her today?
I have not.
Okay, then I doubt she's out there.
Well, Your
She's
Honor,
out there, you can do a warrant recall. Bench warrant will issue for defendant's failure to appear, bond set in the amount of 10,000, cash surety.
thank you, Your Honor.
That warrant will issue immediately. Those case people versus Anthony Johnson.
Assistant Public Defender Sandra White on behalf of Anthony Johnson.
Johnson's here. He wasn't in the hallway.
Oh, I
Wait, go
know.
ahead. I'm just saying.
I want to go help my
Your name, sir? Anthony Johnson. Thank you.
Your Honor, we're asking for an adjournment for further negotiations. Prosecutor, he has requested some information from me.
Pardon?
He has requested some information from me.
Probable cause conference. October 30th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Thank you. Thank you, sir. Court calls the case of the people versus Christopher Kosnick.
People. Chairman Radish on behalf of Mr. Koznick, who should be appearing by Zoom. Is he not? Sorry? Oh, I just called him 2 minutes ago. He said.
Did you?
Yeah, I
Did he answer?
he did answer.
He's not here, though.
Would Your Honor pass it? He literally told me I need a minute to log in. He was ready to log in at 12:30. I told him to hold off on it. So it's actually my fault.
Okay, then the bench warrant will be your fault. What?
Oh, that is Mr.
He's here.
Christopher Koznick.
Did he finally check in?
There's a galaxy that he just let in. He wouldn't have heard if he's called. That's him.
How do you know?
She has him.
How do you know?
He's,
How do you know?
he was a client.
How do you know?
I know.
How do, yeah, I know. So why are you butting in? Why? Why?
He's the best.
Mr. Kosnick?
Yes, Your Honor.
I figured it was you. We waited.
My apologies, Your
fault.
Honor.
It's okay.
My apologies.
You're fine. Your attorney's got issues, but you're fine. All right, what are you doing today?
Your Honor, we are waiving preliminary examination.
All right, is that correct, Mr. Kosnick? You're waiving your right to a preliminary exam?
Yes, Your Honor, I am following the advice of my counsel.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense of stalking was, as alleged, was committed and that you committed it. You understand that?
Yes, Your Honor.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant bound over to circuit court on a single count.
We were from reading of the charges and standing, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
December 4th at 1:30 with Judge Slay.
December 4th, 2025, 1:30, Judge Slay.
Thank you, Your Honor. I appreciate you.
Thank you, sir. Bond will continue.
Thank you, Your Honor.
I don't know. If you're asking, I get an option what to say, right? Court does call the case, people versus, this writing is killing me. Osandu, Visca,
Yes, Your Honor.
Laika.
And Assistant Public Defender Nicholas Bukovitz on behalf of Mr. Wakaka, who's appearing via Zoom.
Nikaka. State your name, sir. There you are.
Osandu Likaka.
Okay, thank you. All right. What are you asking for adjournment?
Yes, and adjournment to continue some negotiations with the prosecutor.
Probable cause conference in this case will be adjourned October 30th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case of the People versus Derek Shipman.
That's all, people.
Assistant Public Defender Sandra White on behalf of Derek. Take the name for the record.
Derek Shipman.
What are we doing?
Your Honor, we're requesting a preliminary exam in this matter.
Discovery is complete.
Yes, Your Honor, to the best of my knowledge.
Court received the bond violation report.
I am. People have their witnesses available the 21st.
You know, we can try for that date. I had extended a plea form, plea offer to the defense, so I just was surprised to hear the question exam, but we'll try for that date.
October 21st, 2025, 9 a.m. before me. We have a bond violation. Have you seen that, counsel?
I have not discussed it with Mr. Shipman. It's my understanding they're requesting extra testing. I've talked to Mr. Shipman and I have now lots of medical documentation. Mr. Shipman has, due to medication and medical issues, he falls asleep at different times and is unable to awaken. I can provide the documentation to the court and to the prosecutor.
He needs to, first of all, make sure that he can make some payment. He needs to pay on his balance over there. This is rather outrageous, his balance that he owes over at Community Corrections. With reference to his testing, you're indicating then no matter how many tests he have, he's gonna have issues?
They've changed, he's asked to be taken off of one medication and the doctor has taken him off of that one. So he's hoping that.
Well, why wouldn't I just put him on a scram?
Your Honor, I have medical documents. They try to do that before I have issues with my legs. Everything is in the folder that I brought today. I thought she was gonna hand it to you.
That what?
I thought she was going to hand it to you. I have all my documentation in the folder that I gave to my attorney.
As I stated, he just provided me with documentation
Of what?
from his doctor stating his different medical issues.
I understand that, but that doesn't get me to his testing.
That's why he falls asleep. He's unable to awaken at the hours that he's now able to, has to test. And adding additional hours won't help it. But I understand you still want him to test.
Well, here are the options.
Okay,
The options is he can go on a scram. I can add additional hours,
Yes, sir.
or I can revoke his bond and put him in jail. Those are his options. Which one would you like?
The additional testing will be fine, Your Honor. But I did want to ask for one request. My doctor did ask if it could be adjusted from the 6 to 9 to 8 to 11. That would give me a chance to be able to wake up and not miss any more tests. And again, I do have the documentation from
You're on 3 times a day per testing now, or 2 times?
one time in the morning. At first it was 3, then I got it down to 1
he tests one time a day.
in the morning.
Who put it down to 1?
I'm on probation at the 15th and I've been doing it since.
Oh, dear.
I think the court should be aware this is an OWI where the defendant is charged with trafficking, which snowbank pass automobile, BAC .182, and then has a RNO attached to that. When he had contacted the police, I would request a scram. I have the same concerns the court has expressed about if there's issues with being able to be awake to complete tests, then I think continuous alcohol monitoring is the best and most appropriate way to keep communities safe.
He's testing 1 time per day?
Yes, Your Honor. If we could just adjust that to 8 to 11, 8 to,
No, 1 time per, I don't even understand why bother. It's 1 time, that is totally philosophically against. I realize some courts do it. I know. That's not how I roll. So I'm going to, here's what I'll do. We'll set it, I'll set the preliminary exam. We'll have it on the 21st. That's before me in person. I'm signing a new community corrections order. You're going to test 3 times per day.
Yes, sir.
That's a sober link. He says he medically can't handle a scram. Thank you, Bond. Continue.
Yeah.
Court calls case People versus Unite Singletary. I did that wrong. I know I did it wrong. It's been a long day.
I
Did I
believe
get
you
it
did
right
it well,
this
Your
time?
Honor.
I knew it. See,
Assistant Public Defender Davi Luba on behalf of Unai Singletary, who appears via Zoom. Ms. Singletary, could you please state your name, ma'am?
Unite Singletary.
see, and I worked really hard, Miss Singletary, to make sure I didn't mess up your name this time. I did pretty good. Aren't you proud of me?
Yes.
Thank you. All right. What are we doing? She's entering a plea.
Yes, Your Honor, I believe that we're already
Are we
done.
sure this time a crime's been committed?
We are extremely sure, Your
Okay.
Honor.
I have before me a plea form that indicates that she's pleading to disturbing the peace, the 90-day offense. Upon her successful guilty plea to that charge, the count one, the possession of a taser, this is very much in the same vein as the other one earlier today, will be dismissed. She is also agreeing to forfeit any interest in the taser currently held by the UMM Police Department or EMU Police Department.
That is correct, Your Honor. If they have been in agreement with Haida,
There was.
Oh, I see it scratched off to the side, but it says Haida.
apologies, Your Honor.
All right, no, that's fine. All right, I just thought. You guys in your paperwork, I just. I don't have defense counsel's signature on the plea form. I have.
Your Honor, if I may approach.
Yes.
Oh.
We did sign it. Where? That's your signature?
Yes, yes.
All right, whatever. Ma'am, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again for the record.
Unite Singletary.
All right, ma'am, it's this court's understanding that you're going to be pleading guilty to the charge of disturbing the peace. That is a misdemeanor punishable by up to 90 days and or a $500 fine plus court costs. You understand that?
Yes.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. You understand?
Yes.
Understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You had previously signed an advice of rights form, is that correct?
Yes.
Do you have any questions regarding any of those rights?
No.
You understand that you will be waiving all of the rights contained on that form.
Yes.
Understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty?
Yes.
Hang on one moment, Ms. Wiley. Find my information here, I'm sorry. On the date of December 12th, 2024, at the location of Putman Hall, EMU, Eastern Michigan University, City of Ypsilanti, what'd you do on that date that makes you think that you're guilty?
Me and my friend were playing around. We're both from Ohio, and we didn't know that the laws are different here, and we were playing around with the taser.
You were playing around with the tasers. You had a taser?
It was not mine. It was the other girl involved with this case.
Your Honor, may I have voir dire?
That always goes badly, but yeah, go ahead.
Thank you. Ms. Singletary, on the date the judge mentioned, were you and your friend in the hallway at the dormitory with the taser in your possession?
Yes, for about 3 seconds.
Okay, and when you,
Say 30 seconds or 3?
3. 1, 2, 3.
well, and while you were doing that, were you and your friend engaging in each other in such a way where you were holding the taser and that gave concern to a staff member who contacted police?
Yes.
What exactly were you doing, Ms. Singletary?
We were playing, me and my friend are both from Ohio. We were playing around with her taser that she had brought onto the campus. I never would have known that there was a taser if it would. It's her taser. We were playing around. We ran into the hallway for about 3 seconds. And once we noticed that, like, we're doing too much, we came back in and now we're here. So
When you say you were doing too much, do you mean that you were saying you were creating a scene that caused attention?
yes.
Is this case related to the other?
No, Your Honor, may I have voir dire?
Sure.
Ms. Singletary, did you chase your friend / roommate with that taser?
Yes. It wasn't my
And did you-
roommate though.
Okay, your friend, and did
Yes.
you arc it? Did you activate it while you were chasing her?
Yeah. Can I say something? I'll just say yes, yes.
Well, no, well. Okay.
Can I
get
say
it.
something?
No, just listen. I know, and it gets hard. This is the second time that we've been through this, and but here's the thing. What I don't want you doing is I don't want you just saying something for the purposes of just saying it. If somebody asks you a question you don't know, it's okay to say I don't know.
Okay, I'm gonna say I
But
don't.
What I need. Go ahead.
I'm gonna say I
You're gonna-
don't know to the activating it in the hallway because when we were in the hallway, there was nobody out in the hallway. That's why we were so surprised when the police came. We actually went to we just proceeded with our day. Like we were not even in there when the police came. We never were arrested or anything. That's why this whole case was surprising to me because I never got like arrested. They did end up taking the taser, which because she said it was hers. I never knew it was gonna fall onto me because I never got removed from school. I never got any of that. My friend did, and I never. They said because it wasn't mine, it didn't really have anything to do with it because I don't believe that I activated the taser. I will say that I did have it in my hand in the hallway, but I can't say yes to me activating it in the hallway.
Ms. Singletary, while you had the taser in your hand in the hallway, were you chasing the other person?
Yes. But when you say chasing, it was literally a door over, as you can see in the camera view that you have, I believe. It was never down the hallway. There was literally nobody in the hallway.
You guys done?
Yes, I'm done.
No, not you. You're
I'm
you're
sorry.
good.
I'm sorry. Can I say something else?
Heck, why not? Everybody else has.
I just feel like I should, even though I'm saying I don't know to some of these things, I feel like I should just go through with it because my friend did end up going through with hers, but our situations are different because it actually was hers. I feel like if I keep just pushing it back, it's just going to be more and more court dates, you know? This is new. I never had nothing going on like this.
Okay. You know, Ms. Singletary, I get it. I hear you. But I hear you, but I am of the belief you don't think that you've done anything wrong as I'm listening to you.
That's what I'm saying, but I understand
Hold on. but I think you're saying things so you can try to get it over with. And I'm not
Yes.
saying that there's anything wrong with that necessarily. What year are you in school?
I'm in my second year. Next year I go into actual nursing school.
Council approach. Singletary.
Yes.
All right. Here's what I'm gonna do. Okay.
Mm-hmm.
There are two major concerns here, and I have to make sure before I take a plea that everything at least has been explored and explained to you. Part of the reason that we're here today is because I didn't feel that that was happening the last time, right?
Okay. Yes.
So we're here now. I have some concerns about what your legitimate feelings about your participation in the case are,
Mm-hmm.
and whether or not you're really guilty of anything. And so I have some hesitancy to accept your plea based upon that. But there's a more overriding issue in a certain respect for the court, and that's as to whether or not you've fully been advised of all of the reasonable consequences that are there, including what are called collateral consequences. One of those collateral consequences for you revolves around your education, right?
Mm-hmm.
And what's your aspirations in terms of being a nurse are, correct?
Mm-hmm.
So there needs to be some understanding, or at least an assessment. I'm trying to put this very carefully, but an assessment of what it may mean for your entry and maintaining yourself in nursing school, as well as once you finish that with flying colors, whether or not there may be ramifications regarding licensure. You hear me?
Yes.
Okay. I think all of that needs to be explored and a discussion had with you about all of that before you make some decision about what you're going to do.
Yes, because I was never told about it would affect my nursing.
Hold on.
I'm sorry.
I don't want to know what you and your attorney may or may not have discussed. Okay.
Mm-hmm.
Because I don't get into that, and that is whatever it is. But when I have somebody like you, particularly who's a student, you tell me what you want to do. I know just based upon my experience, and I guess being here since the dinosaurs, what can possibly happen. Okay. And I want that at least talked through with you. It may be nothing. It might be something, but it's a risk, certainly, that you have to assess. And I'm not, and for me, I'm just telling you, Ms. Singletary, the way I look at it, probably wouldn't do any jail time. Probably going to be a fine, then you're done with it. But for me, this is about a bigger picture, and that's what you want to do with your life and your future. So, in that regard, that's a long way of me saying, once again, Ms. Singletary, I am not taking your plea today. Okay?
Okay.
Not going to do it. And quite frankly, nobody can force me to do it, so I'm not doing it. I'm going to adjourn this out to allow that entire conversation to take place so you understand what are not only maybe actual consequences of your plea, but what may be that collateral stuff coming at you, coming up into this next year and even beyond that.
Okay.
Fair enough?
Yes.
I know you said you wanted it over. You mad at me?
No.
Okay, I didn't care, but I just thought I'd ask. Okay. Here's what I'm going to do. Probable cause conference in this case is going to be adjourned to November 6th, 2025, 9 a.m. or as your invite indicated, this time the defendant's bond will continue.
Thank you. Have a good day.
Pardon?
You'll keep the plea form in the file?
Yeah, we'll figure it out.
Thank you, Your Honor.
All right. Thank you, ma'am.
You're welcome.
Court calls case, People versus Joanne Thompson.
Assistant Public Defender Jay Bellinger, on behalf of but not with Ms. Thompson, Your Honor, and I am in receipt of the Community Corrections progress report. I will say that I didn't see a lot of progress on there. However, I did talk to my client about checking in with Agent Kerr this morning. I did check with Agent Kerr to see if she had appeared to test and reschedule her CCOP. However, Ms. Kerr said that she was not there and that she had not checked in today.
Bench warrant will issue for defendant's failure to appear. Bond $25,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor. Have a great day.
You do the same. Sir. Court calls case of the People versus Vershawn Vincent.
Calls for the people.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Vincent, Your Honor. My understanding, Ms. Apple did call in the courtroom and outside. We have tried to reach him. We've had no contact.
I'm sorry.
It's my understanding that we have tried to reach him. We have had no contact. We are endeavoring to do so. I'd ask the court for a show cause.
I don't know why you do that. You know I'm not doing it. I think you just do it to irritate me. Bench warrant will issue for defendant's failure to appear. Bond $25,000 cash surety. That warrant will issue immediately.
I think Gretzky said you miss 100% of the shots you don't take.
It is okay. Court calls the case, People versus Brenton Warren.
Trevor Mazel for the people. Michael Gaddy, Assistant Public Defender on behalf of Mr. Warren, Your Honor.
Everybody got that M on. All right, what are we doing?
Your Honor, I've submitted a green sheet. We're asking for an adjournment. I think there's some video we need to get a look at.
Has he taken his?
He did, yes, Your Honor. He did, we got the notice from Community Corrections yesterday and he went shortly thereafter and tested, is my understanding. And
When?
yesterday around 4, correct?
I tested yesterday. I got them about 3:45. I think I wrote on the paper. I have the receipt. I tested a negative.
You have weed?
The receipt, no.
What time did you test?
About 3:45. I wrote down on the paper.
Can you ask? I'll pass the matter briefly. You can have a seat out there. Don't leave the courtroom.
Okay.
Thank you,
We're
Judge.
gonna double check. Court does call the case, People versus James Williams.
Trevor Maybell for the people, Your Honor.
On behalf of Mr. Williams, who should be appearing by Zoom.
We don't have him and his Zoom appearance would have been revoked.
I'm sorry, say it again.
It would have been revoked because of the violation report.
He says he's on.
He needs to appear in person. Why is he missing?
He's at work right now.
No. Why is he missing testing?
Oh, Your Honor, I didn't
You don't have the violation report?
know, and I looked through.
Well, it's rather empty, so it'd be quick for you to get through because he doesn't go. Read faster than that.
I do.
It can't take that long because there's spaces.
And Your Honor, I have not spoken to my client regarding Ms. Test or not going.
Where is
into
he
testing.
now?
He is, he's at work in, I believe it's the Detroit area. Where are you?
We're all in the Detroit area. I don't know what that means. Here's what I'm gonna do for you, Miss Cannon. You'll be able to talk to your client. Mr. Williams?
Hello?
Hello?
He's there.
Here's what I'm gonna do. I'm gonna adjourn your probable cause conference 1 week to October 16th, correct? 2025. 9 a.m. as your invite indicates. You've got some problems with your testing and a violation report. You need to appear at that time, and this will be an in-person hearing. You cannot appear via Zoom. Bond will continue.
Thank you so much.
You're welcome. That was a nice thing I've done today. That's it. Courthouse case, People versus Damian Williamson.
So, Your Honor, I will get him. He were this dedicated. He was out in the hall with his baby. I'm sorry.
What? He was out in the hallway with the baby.
Yes.
Is that his?
Yes.
Okay. Might need to ask sometimes, Sarah. How you doing? Doing well.
Afternoon, Judge Michael Gaddy, Assistant Public Defender on behalf of, Mr. To my right, state your name, Mr. Williams.
Damian Williamson.
Your Honor, I have discussed, I have, we have submitted a green sheet here. I'm asking for an adjournment while we continue discussing plea.
I will adjourn. Probable cause will be adjourned to November 6th, 2025, 9 a.m. Bond continue.
Thank you, Judge.
Thank you, Your Honor.
Thank you, sir.
Good.
You too. Yeah, now I'm going. Court calls case of the People versus Jennifer Burnside.
As well as with people.
Good afternoon, Your Honor. Jason Hagelsberg here on behalf of Defendant Jennifer Burnside, who is present.
Good afternoon. All right. What are we doing?
We're going to ask for adjournment to further discuss some plea deals that are proposed.
Okay. You have a medical marijuana?
Yes, Your Honor, but I am going to surrender it.
Your Honor, for clarification, Ms. Burnside does have a medical marijuana card. She has ceased the use of that at the time of arraignment. There are positive, I received this report on the 12th and the 19th. I would suspect that if there were numbers included, those are going to be decreasing. She's assured me of that. There's a dilute on the 23rd. That is, we're at a loss as to why that would happen. I've advised Ms. Burnside, and she has agreed that if there were errors in testing, she would appear and go to the ER, get a blood test to double verify that. She's taken drastic steps to maintain sobriety. She's attending AA twice a week since the time of arraignment. She's got a upcoming meeting with Dev over at Dawn Farms for an outpatient review. She's participating with the state police Angel program. She has a program peer recovery coach. She's volunteering, and she is attending services with her church as well as Celebrate Recovery on a regular basis. So with those steps, I'd ask the court to consider, she's been advised that she should check with the facility she tested today. I told her, if you are, make sure that there's not a dilute.
Correct.
We're just
That
at
looks
loss.
worse than.
And I think, Your Honor, the part of the reason why this case, we did ask for both the scram and the testing is because this is an OWI third offense where there was both a .106 of alcohol and cocaine present in the defendant's system.
Correct. Okay. I'll adjourn it out. Will the 30th work for you, counsel? Or you want?
30th will work, Your Honor.
Probable cause will be adjourned October 30th, 2025, 9 a.m. Bond continue.
Thank you.
Thank you, Your Honor.
Thank you. Court calls case People versus Amber Cormos.
As well as for the people.
Good afternoon, Your Honor. Jay Grant Miller, P58658, on behalf of Ms. Cormos, who stands to my right. Please state your name.
Amber Cormos.
Your Honor.
For an adjournment, counsel.
Yes, we're continuing some negotiations towards possible resolution. We would ask for a date in November as Ms. Cormos is undergoing a medical procedure that might help myself and the prosecutor better lay out a future. for this
November
case.
13th.
That would be fine.
November
13th.
13th. 2025, 9 a.m.
Thank you, Your Honor.
Yep, bond continue. Court calls case of the people versus our morale goal.
Asphalt for people.
Good afternoon, Your Honor. Dan Garrett on behalf of Ms. Feldman. State your name.
Armorel, go.
There's a green sheet for screening into sobriety court, please.
All right. Do you know what track they're on and how different? Okay.
I think we.
Which is it for the 22nd, sir? Judge
go-
Conkey, or which court are you?
Oh, I'm sorry, Your Honor. It's 14A1.
Oh,
Yes, you may know the track.
we're, no, yeah, we're
All
quick.
right. Yeah.
I'll put it out to November, or not November. I'll put out October 30th,
Perfect.
2025, 9 a.m. Bond will continue.
Thank you.
All right, thank you. Court does call the case People versus Tyler Van Effen.
Asphalt for people.
And again, Your Honor, Dan Garrett on behalf of Tyler Van Effen.
Tyler Van Effen. All right. Requesting an adjournment.
I am, Your Honor, for further negotiation.
Put it over that same date for you, October 30th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Court calls case of the People versus Beverly Joe Tuttle.
Asphalt for people.
Before 2505 on behalf of Ms. Tuttle, who's on Zoom.
Ms. Tuttle,
Good afternoon, sir.
good afternoon. Okay, you got her. Okay. What are we doing?
Your Honor, we'll request an exam.
No discovery complete.
Yes.
People have their witnesses available the 21st?
We'll try Your Honor for both cases.
Yes,
Try.
What date, Judge?
the 21st.
Not available on that day, sorry. In a jury trial in Third Circuit. Second day of a jury trial, sorry. I think we'll be done. So I'm available on the Thursday, the 23rd, or it has to be a Tuesday.
You've been coming here how much?
I don't recall.
Then you should know what day our exams are held. It's Tuesday. The 28th.
I'm available, Judge. Thank you.
Preliminary examination in person, October 28th, 2025, 9 a.m. That's before Judge Washington.
Thank you, Your Honor.
Thank you, Judge.
Bond will continue.
Thank you.
Well, I'll see how far I can get through before I have to rest my weary head. Court calls the case People versus Anthony Alexander.
Good afternoon, Your Honor. Sam Bernstein with and on behalf of Mr. Alexander. Could you please state your name?
Anthony Alexander.
All right, and you're doing the plea?
Yes, Your Honor.
All right. I have a plea form that indicates he's going to plead to an added count 2 of larceny, attempted larceny, less than $200, and a 6-month offense, 6 months possible incarceration. Upon a successful plea to that charge, count 1 would be dismissed. There is a sentence agreement of 12 months probation with no from jail in Haida. Although the court, I cannot bind the sentencing judge. I do acknowledge that that's an agreement between the parties. There is one thing that was not checked on this. You did explain to him that I would not be a sentencing judge and he would be sentenced before Judge Barr.
Yes, Your Honor.
All right, because the sentencing judge box was not checked, but I will check that. All right. That's a correct statement of the agreement?
I think it was attempted larceny over $200 and less than.
Yes.
Okay.
Attempted larceny over 200, the 6-month offense.
Yep, all correct, Your Honor. Thank you.
All right. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Anthony Alexander?
All right, sir, it is this court's understanding that you are going to be pleading guilty to a charge of attempted larceny, $200 or more, but less than 1,000.
Yes.
That's a misdemeanor punishable by up to 6 months incarceration and a $1,000 fine plus court costs. You understand that? You understand that the fine could be increased at 3 times the value of the property taken. If that's greater than $1,000, that could become the maximum fine. You understand that?
Yes.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge. You'd be sentenced before Judge Barr in the 14A2 District Court.
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Anybody promise you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
On the date of April 9th, 2025, Sellers Hall, number 521 on EMU's campus. What'd you do on that date that makes you think that you're guilty of this charge?
Attempted to take a television.
We have, there's 3 cases from the same incident. If that's why you looked up, because it's out there familiar. There was one earlier today, and this is the second.
This is the second, and then there's another one.
Wrap them all up.
Hold on a second. Did they all try to take the same TV?
There was other property in the room that
Okay, but everybody keeps saying they're trying to take, it's a 24-inch TV.
there was other property.
I don't think they even call that a TV now. You tried to take a TV out of that?
Yes.
Okay, and you didn't have any property interest in that TV? Meaning it wasn't yours?
No.
No? You understand that if and the value of that TV was in excess of $200?
I'm not sure.
Okay, so was other property taken?
No.
Just the TV?
TV wasn't taken either. It was attempted.
You had 2.
Which is why you had the attempted gun.
It was a nice TV, Judge. It probably.
They all back there. So the cases. Inside. So I thought it's time for us to really think about.
Would you stipulate that the value of the TV was in excess of $200?
Yes.
Thank you. All right. Sir, if I accept your plea, you understand that if between this time and the time of sentencing, that if you commit misconduct as defined under the Michigan court rules, that the judge would not be bound by any sentence evaluation or recommendation. You understand that? And you also understand that you would not be permitted to withdraw your plea.
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No.
No, Your Honor.
And has the court complied with the court rule? And would it be, and can I accept this defendant's plea? Let me put
Yes.
that.
Yes, Your Honor.
All right. Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. The pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
October 29th at 10 a.m.
October 29th, 2025. What time?
10 a.m.
10 a.m. before Judge Barr.
And Your Honor, Mr. Alexander.
Are you in school?
Yes, sir.
What year?
I'm currently a senior.
You're a senior?
Yes.
This happened when you were a senior?
No, it happened when I was a junior last year.
Oh, so you're just smarter now.
Yes, sir.
What are you studying or what did you study?
I'm studying business administration.
Why would you get yourself involved in something that could mess everything up for you?
It was really a wrong place, wrong time. Actually, more of a wrong.
I see, I raised kids, so I know that's not an answer. That means I don't want to answer your question. Why'd you do this?
I was with people who stayed on campus and they left their room. I followed suit because I didn't live on campus at the time, which I do now, but I followed suit and it just happened to be a 30-second interaction that led to this court going to jail for a day.
Where are you from?
I'm from Inkster, Michigan.
Pardon?
I'm from Inkster, Michigan.
Well, I know the school, but where'd you grow up?
Inkster, Michigan.
Oh, Inkster. I thought you said I'm from Eastern Michigan.
No.
Oh, you said
Inkster, Michigan. Yeah.
You know better than this, right?
Yes, sir.
What would you say to your family if you weren't able to graduate?
I messed up.
Yeah. How's that gonna work? Yeah.
They'd be disappointed.
Probably a little more than disappointed, but okay, it's fine. We'll continue.
I had one request, Your Honor.
Oh, no way.
I know. You're not gonna be happy with it, really.
Oh, good. After today, yeah, let's do things that just upset Judge Simpson. Go ahead.
He has a school trip to Ohio tomorrow, Your Honor, and he's asking permission to leave the
For
state.
God's sakes, why?
I know. I knew you weren't gonna.
Why do they want to go to Ohio?
It's a campus involvement event to build community and
To
fellowship.
do what?
Build community and fellowship.
In Ohio?
Yeah, it's going to Cedar Point, but it is a friendship event with multiple orgs involved. It's multiple
You know
organized.
what? The way you spun that, you need to become a lawyer. Wow. When are you going?
Tomorrow at 10 a.m. 10 a.m. coming back at 10 p.m. So it's,
10 to 10?
yeah, 10 to 10.
Okay, we locked the border at 10:01. Yes, to travel to Ohio. He can travel to Cedar Point. We put Cedar Point on the order, right? So everybody knows where he's going? Okay, good. All right. Thank you.
I appreciate you.
Thank you, Your Honor.
Have a good one.
Check your email later.
Court calls the case of the people versus Malachi Harris, aka Malachi.
Good afternoon, Your Honor. Christina Costantino appearing with and on behalf of Mr. Harris. Mr. Harris, can you state your name?
Malachi Harris.
Thank you. Told you.
You'd see me at some point today, Judge.
What?
I
No,
knew you'd see me
actually-
at some point.
See, you don't understand. I saw you and that actually brought joy to my day.
Oh, that's
It actually
great.
did. This has been anybody,
Ah.
it was a rough day. And I
Wow.
said, you know what?
That's
In the
great.
last block, Constantina's gonna show up. It's just gonna
Great.
brighten the whole thing.
That's great.
And
You
make
know,
all the effort and turmoil that these rest of these people put me through today worth it.
for sure, Judge. For sure. You're almost through. You're almost,
Yeah,
you're almost done.
almost. I'm getting there.
Almost Friday.
All right. They, I have a plea form. Is that what we're doing today?
Yes, Judge, we are
All
taking
right.
the.
Plea form indicates that it's gonna be attempted larceny, $200, 200 or more, but less than 1,000. The 6-month offense. Upon a successful plea to that charge, count 1 would be dismissed. There is also an agreement to 12 months probation, no from jail in Haida. The sentencing judge waiver was not signed, but this is Judge Barr's case. Did you explain to him that?
Yes, Judge, we did discuss that. It just wasn't checked on the box.
Okay, and I will check that on the form. All right. May I have him sworn?
Right here. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Malachi Harris.
All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted larceny, 200 to 1,000. That is a misdemeanor punishable by up to 6 months incarceration and $1,000 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than 1,000, that would become the maximum fine. You understand that?
I do.
All right. You also understand that I would not be your sentencing judge, although I'm taking your plea. You would be sentenced before Judge Barr in the 14A2 District Court.
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Sir.
Any question regarding those rights? No. Look at paragraph 5. Those are your rights which are part of a trial. Understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record? To please?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
because you believe that you are indeed guilty of this offense?
Yes.
Oh, boy. April 9, 2025, at the location of Sellers Hall, Eastern Michigan University, Washtenaw County, State of Michigan. What'd you do on that date that makes you think that you're guilty?
Your Honor, may I voir dire?
Is it involving a TV?
It is,
Because
Judge.
I'm almost gonna come off this. Go ahead.
It is. Mr. Harris, on April 9th, 2025, were you at the Sellers Hall location in Ypsilanti, Michigan, located in Washtenaw County?
Yes.
And on that date, did you attempt to take some items that you did not have permission to take?
Yes.
And were those items a TV and some other miscellaneous house furnishings?
Yes.
Okay. And the value of those items, would you agree, was over $200, but less than $1,000?
Yes.
And you did not have any permission to take those items, correct?
Yes.
With that, the defense would be satisfied, Judge.
Sir, I do have to advise you, if between today's date, if I accept your plea, between today's date and your time of sentencing, if you commit misconduct as defined under the Michigan court rule, you first of all the court would not be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
I do.
Counsel, aware of any other promises, threats, or other inducements which have led to this plea agreement?
No, Your Honor.
No, Your Honor.
And has the court complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2. Probation sentencing will be
October 29th at 10 a.m.
October 29th, 2025, 10 a.m. before Judge Barr. You're a student?
Yes, sir.
What year?
I'm in my senior year.
This happened in your junior year?
Yes, sir.
So you're like what the last guy got smart.
Yes, sir.
What's your major?
I major in communication with a double minor in marketing and psychology.
Oh. You figure out the psychology of why you did this mess?
It's just a bad decision. Wrong place, wrong time.
I don't know what that means. Wrong place, wrong time. My kid tells me that. That means you did something. Where are you from?
I'm from Detroit, Michigan.
You're from Detroit.
Yes, sir.
The Big D. Right?
Yes.
Do something. Is a 24-inch TV?
Yes.
Why? I mean, really, why? 24, I could not see a 24-inch TV. I would not know that there were people on it.
Just a bad decision.
So what would your family say if all of a sudden this messed up all your future plans?
They would really be disappointed in me. They would tell me I've come too far and broke too many generational curses to even put myself in this situation, honestly.
See how Detroit's changed? Because I can tell you what my parents would have done. They would have involved a switch, maybe a whole stick. Wouldn't have been a lot of words. Nope. And they'd be right about that, wouldn't they? You don't do these things to mess up your future. You have come too far.
For sure.
All right, he answered my questions. I don't have to revoke his bond. I'll continue it. Second, I'm not going to lock him up.
Thank you.
Thank you, sir. Take care. If I knew who his people were, I'd call them. Just so you get in trouble. They know.
Court of Greenwood County, Kansas, case entitled State of Kansas versus Marcus A. Cook, case number 2024 CR 75. Jill Gillette appears as Greenwood County Attorney, Richard Paws, Defense Counsel, Defendant Cook appearing from the Greenwood County Jail's Zoom location. This matter comes before the court at this time on a hearing on a warrant to show cause. Probation violation alleged that the defendant had left his place of residence with having failed to notify his ISO of the change of residence, and then he failed to report for a scheduled office visit with his ISO, as alleged by Mr. Ketley from the Community Corrections Department, who is present on this meeting with us. I'll also point out that this defendant was originally sentenced in this case for a primary count of theft and received a controlling sentence of 5 months in prison. Mr. Paul, what are your client's intentions regarding these allegations?
Your Honor, he would waive his evidentiary hearing, admit to the violation, and proceed to disposition. Judge, I believe at the time of sentencing, you sentenced him. There were two counts, and you gave him an underlying prison term of 10 months, according to the sentencing journal that I'm reading.
Very well. All right, Mr. Cook, your attorney has indicated that you would now intend to waive any due process hearing that you'd be entitled to, where the state would have the obligation of proving these allegations by a preponderance of the evidence. You can challenge the state's evidence with the assistance of your lawyer, present your own evidence at the hearing, confront the state's witnesses unless good cause was shown. And Mr. Cook, I need to point out to you, among other lesser remedies, the court could consider just an outright revocation of your probation and having you serve the remaining balance of your sentence locked up. Do you understand these things? I didn't hear your response.
Yes, sir.
Okay. So you're waiving a hearing and stipulate and agree that you committed the violations which the court read off earlier?
Yes, sir.
All right. Court finds that the defendant has knowingly and voluntarily waived his right to a hearing in the case and stipulates and agrees that he committed the failing to report address change and failing to report to his ISO as alleged by Mr. Ketley's paperwork filed with the case. We'll now turn to disposition of the Cook matter. What does the county attorney's office recommend?
Your Honor, he has had a lot of issues throughout this case from the beginning. He has 155 days jail credit on his original journal entry. At his first appearance, he asked to do his underlying. I noted that in my file. He actually asked us if he could go do his underlying. I don't know what his living situation is now. He was residentially challenged in the past, not having a home to return to. And I know that it's been difficult for him to maintain a home. I normally would ask for a sanction, but in the case that he's had lots of issues and has wanted to go do his underlying, that'll be my recommendation at this time. However, if the court does sanction him and place him back on corrections, one of his main things would have to be to make sure he always has an address on file with Mr. Ketley or a way to contact him, because that's been a big issue and problem. And I was going to calculate his current credit, but we do have him as an original 155 days. So.
Mr. Gillette, do you know when he was taken into custody on this warrant?
That's what I was looking up, Your Honor.
Your Honor, it was September 4th.
Yeah.
My rudimentary calculations through today gives it 35 days, I believe. But I'm sure the court will be checking my math.
Here to create an aggregate number of days at 190 at this
That's
stage.
that's what I've come up with, Your Honor.
All right, Mr. Paul, your recommendations regarding an appropriate disposition?
Yes, Your Honor. Even though Mr. Cook may have said at his very initial appearance, just given his underline, in speaking with Mr. Cook, he does want to try to successfully complete probation. He does have basically 190 days credit on a 300-day sentence. But Judge, I mean, he admitted to the violation. This is his first violation. I know it's a serious and material violation, and the courts always tell defendants the first thing that they should always do is to report and keep reporting, and Mr. Cook failed to do that. I believe that while he was out, I think Mr. Cook, I believe he told me he did have some stable residence at the time, and he doesn't. But be that as it may, Judge, at the end of the day, he wants to try to be successful on probation.
Very well, Mr. Paul. Mr. Ketley, do you have any independent recommendations or observations to share with the court?
I do not, Your Honor.
All right, Mr. Cook, I'll address you at this time. Do you have any statements that you wish to make in mitigation of punishment here, or anything further that you personally would like to present to the court?
No, Your Honor.
All right, Mr. Cook, I need to have some idea about what your life is like. If you were to be released back into the community, where would you go? Where would you stay?
El Dorado, Kansas, with my buddy's old lady.
Oh.
Which
Your
would
buddy
be
and his old
close-
lady?
No, just his old lady, because they said that I could stay there till I get stable enough. So I will have a job down there.
And what kind of job would you have?
Barrel salt, the cleaning of chemicals out of a container and stuff like that.
It's hard work, Mr. Cook. You think you'd even want to do that kind of work?
Yep. I would rather do that.
All right. Anything else you want to share with the court, Mr. Cook?
That I just miss my mom. She has stage 5 kidney failure, so I gotta get back out to her.
And where is she at?
Missouri.
Hmm.
And I'd rather do my probation and get it over with so I can get back out to her.
Okay. You understand you can't go to Missouri without community corrections officer specific permission to do so.
Yes, I understand that, but
You'd get in
I would
trouble if you
rather
didn't.
do all my probation then go there as soon as I get released from probation. I'd rather get all that done rather than leave and not report.
Court earlier observed that the primary count in this case was 5 months in prison. There's a secondary count also with a 5-month sentence that was run consecutively. So you potentially, Mr. Cook, could be doing 10 months in lockup. You've done a considerable amount of your sentence already. And I wonder if you're just not on a definite path to failure here. You don't seem to want to do the probation conditions that have been imposed. A court certainly understands the recommendation for just an outright revocation and having you serve the remaining balance of your sentence in prison. And perhaps even you merit that at this point. However, the court's uncomfortable with doing so. This court is going to sanction the defendant with a 3-day dip, which runs prospectively. I know you've served some time recently, but that doesn't count toward the 3 days. And then you're to be released 3 days from now, back on the community corrections to satisfy any remaining conditions. Mr. Cook, I will require you to live either in Butler or Greenwood counties. You say that you have a place in El Dorado, right? So you must live in Butler or Greenwood County, and your ISO must always be informed as to where you are residing.
Yes, sir.
Must also satisfy any condition of the original probation that you haven't fully satisfied.
Yes, sir.
I hate to use terms like last chance, Mr. Cook, but I think that's where you're at. Look, if you can't be successful on your community corrections at this point with the chances that you've already had, then perhaps prison is the only remaining remedy here. And I don't think you really want to be in a men's prison in Kansas. I really don't. So straighten up and do what you're supposed to do, Mr. Cook. Mr.
Okay,
Ketley will
thank
work
you.
with you if you communicate with him.
Thank you. Can
And
I
you,
get his
you will have a
number, though?
job above, not under the table, but a paycheck with withholding.
It's gonna be a paycheck with a pay stub.
And then you'll be showing those pay stubs to Mr. Ketley so that he can verify that you are working a legitimate job.
Okay. Can I get his number?
Mr. Ketley, what number should he use? Perhaps that can be written down for him at the facility.
Yes, Your Honor.
My direct line is 316-322-4296.
So I gotta do 3 days here?
You got to do 3 more days.
Okay.
Yeah, Marcus, call me on Monday.
Okay.
You'll get out what, Sunday. Call me on Monday.
Okay. I will
All right.
make sure that
You had something you wanted to say, Mr. Cook?
thank you.
All right. Well, you're welcome. But again, just do what you need to do to satisfy your probation conditions so that I don't have to review your sentence again.
Okay.
Okay, I'm going to waive any additional bids assessments because of his considerable period of incarceration that he's had. I doubt if he has the financial resources to be paying any additional amounts. Anything previously imposed still remains to be paid.
Is he extended, Mr. Ketley?
I'm sorry, I missed the first part of that.
Does he need extended? He was sentenced August 15 to 18 months. So he would have,
Yeah, he's due off in February, and if it gets to the point to where we can extend him at that point in time.
okay.
All right.
I do got court coming up August 21st in Sedgwick County, so I don't know how to do with that.
All right. Why are you going to court in Sedgwick County in August, Mr. Cook?
It's just for a bench warrant that I had in 2023. And that was just, I'm trying to get that done and over with. So I thank you for reinstating my probation.
All right. What's the bench warrant for? What kind of case?
It's just a ticket that I gotta pay.
All right. Take care of that, Mr. Cook. I don't want Sedgwick County complications. And I don't want you locked up over there because I want you reporting to Mr. Ketley.
Okay. Okay.
All right. Good luck with that. I hope you get things worked out with Sedgwick County. We don't have to get locked up for a long period of time.
Thank you.
All right.
Good luck, Marcus.
If there's nothing further, then the Cook matter will be in recess and we'll move on to another matter.
Judge, I emailed Mandy about the 10 o'clock. He's in custody as well. I didn't know if you wanted to take it up now.
I told her that I did.
Okay, I never got anything, so that's great.
Sorry, that was my fault. Do
Oh,
we switch to a different link, or do you want to do it on this link?
Do it. If the jail can bring him in, we'll do it on this link.
Okay, yes.
I don't know if there's any other participant. Is there? Mr. Ketley, are you on this case as well?
If it's Mr. West or Thorne. Which one? I think it's Caden West, I think.
Wait, it's West.
Yeah, Caden West. Yes, I am. Yes, I am.
Okay.
Your Honor.
All right. Then I see no reason to get off this link.
Perfect.
Why risk another technology issue?
Well, thank you, Judge, for taking this up so quickly.
Mr. Paz, today a special day.
It is. I'm old.
Hey,
Happy birthday, counsel.
Well, thank you, Judge.
All of us turn 50 sooner or later.
Well, I'm past the 60 mark, Judge, so. But I'm still 14 on the inside, as everybody well knows.
Mhm.
And with that smirk, I think you'd understand.
I do. Smirk?
Well, that's what you kind of did, Judge.
Okay, so I trust does the jail know to extract Mr. West?
I think they went to go get him.
Okay.
My birthday always seems to land on a jury trial lately.
That's your present.
It is.
My present is I'm stacked back to back to back in court all day.
Me too.
There's Mr. West.
Caden West?
Yes, sir.
All right. Court at this time calls the case of State of Kansas versus Caden Joseph West. It is case number 2024 CR 231 in Greenwood County. Jill Gillette appears as Greenwood County Attorney. Richard Paz, Defense Counsel. I'll note the presence of Ed Ketley from Community Corrections. Caden West appears from the Greenwood County Jail's Zoom location. This matter comes before the court at this time for a hearing regarding a warrant to show cause alleging probation violation. Essentially, the alleged violations in this case are that the defendant failed to report to Sedgwick County Community Corrections. He didn't respond to attempts to communicate back with him, and his current whereabouts were unknown at the time of the issuance of the warrant. What are your client's intentions regarding this particular case, Mr. Pa?
Judge, we are going to admit with explanation. We're going to Mr. West is going to waive his evidentiary hearing, and then we'll be proceeding to disposition.
All right. Mr. West, your attorneys announced that you now intend to waive any due process hearing that you'd be entitled to, where the state would have the obligation of proving this allegation by a preponderance of the evidence. You can challenge the state's evidence, present your own evidence with the assistance of your lawyer, confront the state's witnesses unless good cause was shown. I do need to point out to you that among other lesser remedies, the court could just revoke your probation outright and having you serve the remaining balance of the 8-month sentence in prison that was originally imposed back in June of 2025. Do you understand these things, Mr. West?
Yes, sir.
And do you now stipulate and agree that you committed these violations and in doing so, waive a formal hearing in the case?
Yes.
All right. Court finds that the defendant has knowingly waived his right to a hearing and stipulates and agrees that he committed the violation, though I will note defense counsel's qualification that there is an explanation to be given. The court does find that the allegation, as admitted to, is a substantial and material violation of the terms and conditions of Caden West's probation. Court will now turn to each party for a recommendation regarding an appropriate disposition, beginning with Jill Gillette on behalf of the state of Kansas.
Your Honor, this is also a first time revocation. I would ask for an appropriate sanction. He has originally had 163 days of jail credit towards his 8-month sentence. He does have credit for the time that he has been picked up until today. we're looking up those exact times.
He was arrested August 12th per the warrant to show cause and transfer in Butler County and transferred to the Greenwood County Jail on August 13th.
So we'll ask the court to grant him credit for that time for his warrant to show cause time till now, and an appropriate sanction.
Mr. Paul, are you doing the addition?
I have, Your Honor.
221?
Yes, Your Honor.
Okay. Does appear to the court then that Mr. West has served 221 days of his sentence at this point. Mr. Paul, what do you recommend regarding disposition here?
Judge, first of all, I would like to address the explanation. Mr. West has reported to me that he has never moved. He has actually lived at that same address. He has also reported that he has had known mail issues forever at that address. Mails being misdirected, stolen, whatever. He wasn't trying to willfully do anything by not responding. He reports that he just never got it, but he understands that since he failed to respond, basically that is a probation violation. Judge, by my calculations, his underlying sentence is approximately 240 days. As the court has just announced, he has 221 days. Judge, I don't know if Mr. West just wants to complete his time and be done with it, or if he wants to be put on probation, back on probation. We have talked about a couple of different things, but I would defer to Mr. West at this time, Your Honor, to see what he wants to ask the court to do.
I would like to just go ahead and max it out.
There you go.
Okay. Mr. Catley, do you have any independent recommendations to make to the court?
I do not, Your Honor.
There is a curiosity in this court file, Mr. West. A rather unusual order appears regarding contempt sanction that you sustained in Judge Webster's court when you made a first appearance on this. You
Yes.
received a $10,000 contempt fine. It does make the court wonder what you did to earn such a contempt sanction, but I don't feel like that should really enter into today's proceedings. Apparently, you have been tried and punished for whatever contemptuous behavior you engaged in. My only point being that if you've engaged in that kind of behavior with one of the judges of our court, I'm not inclined to cut you any slack on your remaining time. However, you don't have a whole lot left. And I think I agree with Mr. Paul. I think that the proper way to consider the number of days of an 8-month DOC sentence is to convert it to 240 days. It does appear that you've already earned 221 days of jail time credit. You've got 19 days left. And the court is going to make you do it all. So the court will order the defendant to serve 19 more days in the Greenwood County Jail, and then essentially your sentence will be considered by this court to be flattened, and you're to be ordered released on this case. Since you are not serving time in DOC, I don't think a post-release supervision period applies. Are you on probation elsewhere, Mr. West?
No, I'm not.
You still owe money on this case?
Yes, but I have been paying. I think I paid a total of $500 so far since I've been here.
Mr. Catley, can you clarify exactly where he stands on his costs and fees?
If you give me just a moment, Your Honor.
Thank you. You have a job to go back to, Mr. West?
Yes.
Doing what?
I collect disability, but I volunteer my time on a horse ranch, and I volunteer my time a goat ranch.
All right. It's just that this debt that you owe to the court isn't going to go away.
I know.
And if it's turned over to a collection agency, you'll owe even more because then you're going to pay collection fees. So the sooner you get that paid off in full, the better off you are. And indeed, the matter may already be in the hands of the collection agency. I don't know.
Your Honor, it looks like I don't see any payments on this case, and he owes a considerable amount, over 10,000.
Right.
Well, I've been putting money on my account here, and they've taken $100 off the top of total of 6 times.
Yeah,
So where that money went, I do not know. Do you know?
Perhaps the representatives of the sheriff's office at the jail can explain that to you, because I can't.
Well, I can't. They can't explain it either.
Okay.
We can go over it, Your Honor, but we don't pull off our fees owed.
Okay. Mr. West, I'm just reminding you that you still have a remaining balance on your case, and even though your incarceration time will be flattened, that doesn't mean that the amounts that you owe on the case go away. Those are immediately due and collectible. So any way those can be collected, they will be. So you're going to just need to make some plans to take care of that. Okay. I'm waiving any additional bids amounts, just given Mr. West's financial and incarceration situation. Anything, again, that was owed previously is still owed, and it is immediately due, payable, and collectible. All right, Ms. Gillette, I don't believe there's any additional orders that the court needs to make at this time. Are you proposing anything else?
Sorry, I was muted. No, I can't modify the prior journal entry that has his post release on it, but if he maxes his time out in the jail, he maxes it out before KDOC gets the journal entry, which probably will be the case. And we've awarded the jail credit on the journal entry for him.
Okay. Yes, it'll need to reflect the crediting of 221 prior days and the court's order to have him flatten his time by serving 19 more, starting now. So in about 3 weeks, you're going to be out, Mr. West. I just hope that you use your time in the community responsibly.
I do. I appreciate it.
All right. Okay, Mr. Paw, is there anything else we need to ask? Hang on, Mr. West.
I don't have anything further, Your Honor. Thank you.
Mr. West, I wanted to ask you specifically, you have any questions about what we've done here today?
No, sir. I completely understand.
All right. If there's nothing further, the Caden Joseph West matter will currently be in recess, and that will conclude proceedings in this case. I believe that takes care of our business with Mr. Paw today.
It does, Your Honor.
Have an exciting and productive birthday, Mr. Paw.
Thank you, Judge.
Happy birthday, Mr. Paul.
Well, I gave you a gift of 19 days, so Caden, good luck to you and thank you.
Thank you.
If there's nothing further, that would conclude this warrant to show cause docket that we've conducted, and we can end this meeting for all at this time.
Good morning once again. We're about to have a formal hearing with testimony on a traffic violation matter. I think I've turned off the chat. Program has changed. All right, this matter is in file number 259070089-SI. I never understood why the civil infractions have so many numbers in them, but they do. It's entitled People versus Robert John McLean. That's you, sir?
Yes, sir.
Mr. McLean lives in Mendon. He's here. He wanted to go right to a formal hearing rather than an informal hearing with the magistrate. Also present is Chief Assistant Prosecuting Attorney Joshua Robert and Assistant Prosecuting Attorney Abigail Stoll. Who's going to be handling this?
Ms. Stoll.
Very good. The jurat was signed by Prosecutor Camfield, So let's talk about this. The allegation is that on August 15th of 2025, Mr. McLean disobeyed a traffic control device on M66 near M60 at 3:54 in the afternoon. That's in violation of 257611 of the Motor Vehicle Code. The ticket states the defendant disobeyed a road barricade at a fatal accident. The magistrate had several other cases, I think, at this same location and time. There was a fatal traffic accident on that day involving a young woman that worked for the county transportation service. And I think that is what this is regarding. So, Mr. McLean, you wish to have a formal hearing, so we skipped the informal hearing stage. Let me just explain. This is a civil infraction. You can't go to jail for a civil infraction, and the burden of proof is lower than it is in a criminal case where the burden of proof is beyond a reasonable doubt. In this case, the burden of proof is beyond a preponderance. So I'll hear this and see whether they meet their burden of proof. Ms. Stoll, are you ready to proceed?
Yes, Your Honor.
All right, this citation was issued by Deputy Hunter Zinsmaster. Mr. Zinsmaster, would you come right up into the witness box and raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes, sir.
Would you state your name for the record, please?
Yep, Deputy Hunter Zinsmaster.
All right, have a seat. Thank you. Ms. Stoll, you're go.
Where do you work, Deputy Zinsmaster?
St. Joseph County Sheriff's Office here in Michigan.
How long have you worked there?
Approximately 2 years.
And then were you on patrol on August 15th of this year?
Yes, ma'am.
Can you please tell me about your contact with Mr. McLean?
I initiated a traffic stop on Mr. McLean after he had drove past road barricades on M66. I was called to watch traffic coming through and out of the barricades because people were driving through the barricades. We didn't have enough people to stop them due to the fatal accident being investigated. That's how I got called down there.
What time of day was it?
It's about 3:54 p.m.
Was it daylight out?
Yes, ma'am.
Okay. And you said this was on M60?
The fatal crash was on 60 and 66. I was on 66 and the barricades were on 66.
Is that in Mendon Township?
Yes.
Okay, and then what happened?
I was facing northbound. I had another patrol car by me facing southbound. The patrol car that was facing southbound had a deputy in it. That also works for St. Joseph County. The deputy advised there was someone driving through the barricades. I turned around, saw a tan truck driving towards me, and I initiated a traffic stop on the tan truck.
How were the barricades set up?
I believe it was one barricade in the middle of the road. I didn't get a good look at them though.
Would you mind drawing the accident and the barricades on the chalkboard, please?
Chalkboard's been here for many years. It wasn't always here, but we don't use it much anymore, but occasionally we do refer to it. So we still have it. It's sort of a historical artifact. All right, north is at the top of this diagram?
Yeah, yes, sir. And then this is not to scale by any means.
Well, you didn't know you were gonna have to do some artwork this morning, but
No, sir.
even a simple drawing like this is helpful for us to understand. So in the drawing, M66 runs north and south, is that correct?
Yes, sir.
And it tees into M60, which essentially runs east and west.
Yes, sir.
And that's on the east side of the village limits of Mendon.
Yep.
And it's in the township.
Yes.
Just south of M60 is a smaller road called Simpson Road. And you've shown that on your diagram. That also runs east and west.
Yes,
Is
sir.
that true?
Yep.
And is there any other road between Simpson Road and M60 that would allow passers to pass through there?
Yes, sir. I believe it is Talon Drive, just north of Simpson.
All right, but that's a
It's
dead
a dead
end.
end, yeah.
All right.
Yep.
All right, thank you. So we can't, I'm not sure how well everybody can see that, but we can see it here in the courtroom. Ms. Stoll, go ahead.
So you said that Mr. McLean drove up through the barricade and stopped next to your patrol vehicle?
So I turned my lights on. It was pointing out of my window, telling him to pull over. There's also another vehicle behind him that got stopped and issued a citation as well.
Please continue.
I ended up stopping both the vehicles. They both got issued the same citation.
Could you please draw where your vehicle was and where Mr. McLean drove up?
Like where the stop happened?
Yes.
So my patrol vehicle is the square, Mr. McLean's vehicle is the triangle.
Where was the other vehicle that was pointed, the other deputy, where was his car?
So I was initially parked about right here. The other deputy is right next to me. We were talking about the crash, what happened.
Okay.
I was pointed northbound, the other deputy was pointed southbound. Due to me being the designated traffic car for the day and the other traffic car investigating the crash, the other deputy advised me that Mr. McLean was driving through the barricades.
All right, Ms. Stoll.
Deputy Zinsmaster, could you also label where the barricade was? You diagrammed it, but could you label it, please?
Just put a B in it for barricade, yes.
And then can you tell me about your exchange with Mr. McLean?
Absolutely.
You can sit back down if you'd like.
Thank you, sir.
If we need to refer to it, we'll have you stand back up.
So as I made contact with Mr. McLean, before I.
Just a minute. That microphone's not triggering on him.
It's really weird.
Gotta get closer.
No. It should.
I would say something.
All right, now I've locked it on the witness. All right, go ahead.
Can you repeat the question?
Could you tell me about your exchange with Mr. McLean, please?
Yes, ma'am. So as I was getting out of my car, Mr. McLean stated something about seeing this crash on Facebook. I then approached him, asked him why he drove past the barricade. Mr. McLean stated he did not drive past the barricade. He drove through the barricades, indicating there were two barricades. Mr. McLean did acknowledge the barricades were there and that he did drive by them. I requested Mr. McLean's ID. He stated in quotes, "Are we really going to do this right now?" I advised him yes. That provided me with the requested information of his ID and his insurance, but he was unable to provide me with his registration.
Okay, and then could you please identify and point out Mr. McLean in the courtroom?
Yep, Mr. McLean is wearing jeans and a gray t-shirt on the defendant's stand.
Okay. Let the record reflect that the witness has identified Mr. McLean.
It may.
So he couldn't provide registration. And then what happened?
I made contact with the other vehicle, came back to my patrol car, issued 2 citations for disobey traffic control device, then issued the citations to both vehicles. Mr. McLean also stated, wait till Middleton hears this. That was the end of the contact.
Thank you.
Mr. McLean, do you have any questions you'd like to ask of the deputy?
Yes, I do. I do.
All right, the problem is I'm gonna take this off the lock. But it isn't queuing on the witness very well. But go ahead and you can inquire.
Deputy Zinsmaster.
It's not queuing on him either. See if you can try to keep up and focus it on the speaker. All right, go ahead.
Okay, Deputy Zinsmaster. You stated that there was one barricade in the middle of the road, correct?
From what I remember, yes.
From what you remember, okay. And you also stated that I told you that I drove between the barricades.
Yes, you said you did not drive around the barricades, you drove through them.
Okay, all right. Now, at what point did you see me drive through the barricades?
I did not see you drive through the barricades. Another deputy sitting beside me said vehicles driving through the barricades.
Is that deputy here in court today? Okay, so this deputy cannot be here to swear to the fact that he saw me drive through the barricades.
No, sir.
Okay. All right, at this point, Your Honor, the barricades, I do have a video of the 2 barricades. They were on either side of the road. They are unmarked. There's nothing written on them. Okay, furthermore.
Well, we're not to your testimony yet.
Okay,
so-
okay, all right, want to say. All right, you're not to my testimony, okay. Obviously, Deputy Zinsmaster couldn't see from Zinsmaster Road to where Deputy Zinsmaster was parked. He can't even see the barricades.
Well, ask him that.
Okay, Deputy Zinsmaster, were you able to observe the barricades from where your patrol unit was parked?
If I were to look in my rearview mirrors, yes.
You were, okay. Do you have the video of that?
I'm sure it's saved on my MVS.
Okay. If we have to continue this, would you provide this to the courts?
Absolutely.
Okay. All right. Because the video I showed directing straight north on, well, I know I'm not supposed to. All right.
Well,
Your Honor.
we'll get to that.
Okay. And what did do you remember what I told you was the reason that I came up through there?
Because you used to be a record company.
And?
That's all I remember. And you
Okay.
saw it on Facebook and you wanted to check it out. I don't know
know.
what your reasoning was for it.
Okay. All right. Well, I believe that I told you that I was interested. Number one, there was no signs up that said stop, no go. Okay. And that yes, I wanted to just kind of observe from a distance of the scene, not to impede on the scene of the investigation. Okay. And at this point, Your Honor, this is all I have to ask the deputy.
All right, deputy, may I step down?
Your Honor, I have a few more questions.
All right, I'm sorry, thank you. I apologize.
I just want to clarify, you said that you made contact with Mr. McLean past the barricades.
Yes, well past barricades.
Okay. Could you please describe the barricades?
Yes, they were orange and a like whitish silver color. Typically what you would see blocking the roadway. I'd say they were about maybe 6 feet long by 5 feet tall.
And where were they positioned in the road?
In the road.
in the center of the road?
Yeah.
Okay. And what did Mr. McLean say to you about him being a former wrecker?
He had stated he'd been on a former record service.
Was he called that day to the accident?
Nope.
Okay, thank you. That's all.
Was he in a wrecker?
No, sir. He was in his, was a, small tan single cab pickup.
All right, thank you. You can step down. All right, Mr. McLean, you have a right to take the witness stand and testify if you'd like to.
Yes, Your Honor, I would.
Would you please raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge.
I do.
All right, have a seat and state your name for the record, please.
Robert J. McLean.
All right, Mr. McLean, go ahead and tell me what you want me to know.
Okay. Well, Your Honor, I had known previously that I'd seen on Facebook that there was an accident up there, which is supposedly, I don't know, an hour or two previous. I was interested in, you know, kind of seeing what had happened without invading their scene. So I pulled up the two barricades, one on either side of the road, which I have a video if you'd like to see it. And nobody was posted there. In 55 plus years of driving, I've never seen an accident scene where they didn't have at least a fireman posted there. So I continued on down. Other cars did continue down that turned onto Talon Drive and turned into the old Hart House there on the corner, which they allowed. I continued up just across the bridge. And after the bridge is when I pulled off to the side of the road. As soon as I cleared the bridge, I got a video of that too, probably 300 plus feet from the casualty. And Deputy Zinsmaster and the other deputy were sitting there in the middle of the road. That's where they actually had the road barricaded. And I just pulled over. That's where I was planning on stopping. After I had stopped, Deputy Zinsmaster drives up to me, pulls over, gets out of his vehicle, and he asked me, "Did you drive around the barricades?" And I said, "No, I did not." I said, "There was an opening between them." So I drove between them and I came up here to take a look and see what was going on. And that's when he asked me for my driver's license, insurance and whatnot, and wrote me the ticket. I came back and said that I had disobeyed a traffic control device. I never got near the scene. I never, where they had blocked off, I had stopped previous to that. So I just went ahead and I took a picture of the truck. I wanted to see, being in the business and stuff. And even if I wasn't, I was just an interested citizen. So I wasn't violating. The prosecutors just offered me a plea of impeding traffic, which I wasn't impeding traffic either. I pulled off the side of the road. So I don't believe that
impeding traffic offers no points, which was the benefit of it.
I understand that, Your Honor. I understand that, but I also have a video that I took in the city of Three Rivers where they have barricades in the road that say, local traffic only, road closed, local traffic only. I've encountered over my years, I've seen barricades in the middle of I-90 that said, water over road, proceed at your own risk. So the barricade that's unmarked and without any type of emergency vehicles or somebody there, that would be not some farmer, but somebody that was involved with emergency services to say, hey, your road's closed, you can't go through, or what's your reasoning? I don't feel that is a proper sign. Just a barricade in the road is not saying you can't come through here. Obviously, they allow other people through there to go to the other roads. So I don't feel in this case that a ticket of any court is even warranted, but also the fact of saying, hey, we're giving you 2 points because you came up and wanted to look at something, and with no intentions of ever going through their scene.
Well, what would be the point of even putting them there?
Like I said, they put those things in the roads for lots of reasons.
All right, let's talk about this case. Why put barricades there? Because they didn't want you to come up on the scene where this young woman was killed. They're busy. They're working on the crime scene, and they don't need looky-loos like you coming up to take a picture and see what's going on because you saw it on Facebook. You don't have a very compelling defense. So why would they just have them there? It's like and I don't have a picture. You have a picture of them.
Right.
Can I see it?
As soon as I can bring it up here, Your Honor.
Now, the statute itself, and nobody's referring to that. 611.
Okay. Your Honor, before I dig that picture out, they updated my phone and they changed all our pictures. This is where I stopped before the scene. That was as far as I planned on going.
All right, Ms. Stoll, you want to see these? Come up and take a look. All right, so I'm familiar with this intersection, and I guess you probably are too. You grew up here. All right, show us what you want to show me next.
Okay, I gotta find it now.
Stick around, Abigail. We'll take a look at the picture of the barricades here. This is an informal hearing, and I guess we're being pretty informal. It's a formal, informal hearing.
Well, here, I'll show you. This is the one I took as an example in Three Rivers.
Just show me these.
Okay, I have to find the video because like I said, they changed a bunch of stuff.
While you're looking at that, what you're charged with violating is the section 257611 of the Michigan Motor Vehicle Code. The driver of a vehicle or operator of a streetcar, I think we can eliminate that. I'll tell you how old the statute is. A driver of a vehicle shall not disobey the instructions of a traffic control device placed in accordance with this chapter, unless at the time they were otherwise directed by a police officer. The driver of a vehicle shall not, for the purpose of avoiding obedience to a traffic control device placed in accordance with this chapter, drive through or upon private property, which is not a street or highway. So then the question becomes, what is a traffic control device? And that was hard to find. That's in an administrative section. And that is found in Michigan Administrative Code Rule 408.42213, Section 2213. 8 says a traffic control device means all signs, signals, markings, and devices placed or erected for the purpose of regulating, warning, or guiding vehicular traffic and providing employee protection in a work zone. So they allege that this is a traffic control device and that it looks like.
Okay, this is the video. Should start playing.
Thank you.
Thank you, Your Honor.
All right. Anything else you'd like me to know?
Yes, just like I said, in all the years that I have been driving, I have come upon many scenes where state police, sheriff's department, whatever, were on the scene where they actually had a roadblock set up. And they've always had emergency services. Now, I talked to one of the firemen after I received the citation, and they had come back out to where the barricades were, because they said that they were told by somebody official that once them boards were put up.
Just a minute.
We have Jack hearsay.
Yes, what the fireman told you is hearsay.
I understand. Okay. but the fire department was told to
All
leave the
right.
scene.
All right,
Okay, they were told to leave the scene, Your Honor.
all right. Okay. All right. Those barricades say, don't drive through here. I'm embarrassed. Wait till Middleton hears this. I have better things to do than hear this. Those say, everybody, including you, Robert McLean, don't drive through here. They are a traffic control device and you disobeyed them. And I find that you're responsible for this. Is a line drive, easy decision. You can't do it. They put them there to keep people like you from coming up on the accident scene. Now, maybe they should have had the officers park up farther. Then they wouldn't have been able to assist at the scene. This young woman, Miss Jones, was killed in that traffic accident and it was terrible. And you're coming because you want to see what's going on. I find that you're responsible for this violation and I'm not sure what the fine is. Do you guys know what the fine is for this?
No,
No, Your Honor.
Did you post a bond?
no, sir.
I think the fine is 35, 45, and 40, 85, and $120. That's 2 and 30 days. You can appeal this, but I think that whoever sees this on appeal is gonna have the same reaction I did. Bear in mind, Mr. McLean, this is a civil infraction, not a crime.
Right.
It does carry 2 points. You could have saved that,
Well,
about $20.
Yeah, Your Honor. Here's the situation, okay, and I know that you made your ruling here, but the thing is that you know, 2 points can affect my commercial driver's license.
I know, you should have taken the impeding traffic.
Well, I didn't feel that I mean.
Well, I
that
felt
it's-
differently.
I
I felt-
understand that, Your Honor, and I respect that.
All right.
You know, I'm just, the points now is my son just got a CDL and I was hoping to be able to get a job with him, you know, teaching.
I don't think this will prohibit you from getting a CDL, but when you were a record driver, you didn't like looky-loos coming up there, interfering, wanting to see what's going on when they're trying to tow the car out of there. You're not a record driver anymore and you're a private truck. So you got a $120 fine, you got 30 days to pay it and you're free to go.
Thank you, Your Honor. Thank you, Judge.
Thank you.
Can I go pay this right now?
Yes. Thank you.
Thank you, Your Honor.